Good morning, everybody. Thank you for joining us this afternoon for the American Constitutional Society's presentation today on federal sentencing guidelines. My name is Vanessa Johannes. I am of counsel at Carlton Field, and today I'll be the moderator for the panel. This afternoon, we have a wonderful panel before you. We have Michael Yeager, who's a fellow colleague of mine at Carlton Field. He's a shareholder in our New York office. We have James Feldman and Frank Bowman, who are both in addition to being renowned lawyers who've worked for DOJ with respect to Frank Bowman and have great backgrounds. They're also pretty well known in the academic sphere. And we have Aimee Ferrer, who for the past several years has served as an assistant federal public defender here in Miami. I'm going to go ahead and let the panelists each briefly introduce themselves and tell you what they expect to cover today in our panel discussion. And then we're going to go ahead and dive into the topic. Mike, since you're first up on my screen, why don't you start and introduce yourself?
Okay. Hi, I hope everyone can hear me. I'm Mike Yeager. And as Vanessa said, I practice law here at Carlton Fields in New York City in the Chrysler Building. White collar defense and cybersecurity mostly, and civil stuff too, related to both. And before that, I was a federal prosecutor in AUSA in the Eastern District of New York, mostly doing white collar crimes and cyber crime, but the other mix of things that come through Brooklyn and Queens too. Before that, firms. I went to Yale for law school, where I studied with Kate Stith and Nancy Gertner on sentencing, and that's what sparked a lifelong interest in this. And I did clerkships at some point, San Melito in the Third Circuit, Milton Pollock in the Southern District. And the last thing is, I have started up this side venture, with the permission of my firm, called Empirical Justice, where I provide statistical analysis with the help of statisticians and identified case law, a database of sentencing case law of previous identified sentences, about 550,000 sentences. So basically, I did this stuff for clients in defense, and I decided that this should be something available to other people. And so now it's part of what I do. And I suppose you can imagine, I'm very interested in talking about what the actual data on sentences is and how lawyers can use it to effectively rewrite the guidelines in every case. Reform doesn't seem incredibly likely to me anytime soon, and so I think lawyers should take it into their own hands.
Excellent, thanks, Mike. Jim, you want to go ahead and take the wheel? Tell us a little bit about yourself and what you're hoping to gain today in the discussion.
Sure. And thank you for including me. I'm Jim Felman. I'm in private practice in Tampa Bay area with Kynes, Markman, and Felman, and we do mostly white-collar criminal defense work. And I started practicing just as the guidelines were coming online, and so I did some pre-guidelines practice, but it was kind of the new thing. So I became interested in the sentencing guidelines when I was a young lawyer and still willing to learn new things. And so I've just had a policy interest in sentencing law throughout my years of practice. And along the way met, of course, Frank Bowman, because anytime you're in the federal sentencing sphere, you're going to run into Frank. So we've been friends for many years, and I was able to cajole him into joining us. So I understood what we were going to do today to talk a little bit about how we got here and kind of the history of the federal sentencing guidelines, and then what the prospects for the future or the options for the future might look like. So I'm going to try to sketch some of the beginning of that history and then kick it over to Frank to finish the history, and then come back later in the discussion and talk a little bit about what might come next.
Thank you. And Frank, why don't you take it and tell us a little bit about yourself, and also you were very much involved in the Sentencing Commission. Can you just tell us how that came to be?
Well, I suspect that I'm the oldest of this distinguished crew, as evidenced by the fact that I first joined the Justice Department in the Carter administration, if you can believe that, right after getting out of law school. Of course, at the very tail end of the Carter administration, and which then became the Reagan administration. But I was in the Justice Department twice, once in Main Justice, later as an assistant U.S. attorney in in Miami. In between, I was a deputy district attorney in Colorado and practiced state criminal law, a private practice, and then after about 17 years of being a real lawyer, I became a pointy head, and I've been teaching at a variety of law schools over the years. I'm now at the University of Missouri, and I'm also a visiting scholar at Georgetown. And as Jim points out, really far too modestly in his own case, he and I have been talking about the guidelines together for a really long time. Jim has been not the close to the leading, probably the leading voice on the defense side for several decades. And so we go back a long way, and we've argued about practically everything, although our views have had a regrettable tendency to converge. So it's like singing Kumbaya now most of the time, whereas we used to fight like cats. So I continue to write about the guidelines, albeit a little bit less than I used to. Do a treatise. Some of you may have seen the Federal Sentencing Guidelines Handbook, and have inflicted countless law review articles on a horrified public for several decades. And in particular, one thing I will talk about today, probably, I was pretty involved, along with Jim and many others, in creating the current iteration of the white collar guidelines. But in terms of what I'm going to talk about mostly, I'm just going to let Jim tell me what I should talk about, and I'll talk about it.
Sounds good. Frank, you do not look like you started working for the Department of Justice during the Carter administration. So that was news to me. Aimee, why don't you go ahead and briefly introduce yourself? Aimee and I work together on many cases, so it's nice to see you on the panel. Go ahead, Aimee.
That's right. Thanks, Vanessa. It's nice to see you too. So I am an assistant federal public defender here in Miami. I've been practicing here at my office since 2009. So I have always practiced under advisory sentencing guidelines. Although when I started, I had a number of colleagues who were, recent memories of the mandatory guideline system, and who would tell me the old stories. So it's not foreign to me when they were mandatory. I think my addition to the panel is that I am a practitioner who has participated in many, many sentencing hearings. And in fact, before this panel, I was actually gluing together my sentencing book. Because we haven't had a new manual since 2018, my book is actually falling apart right now. That's how much use it gets. And being here in South Florida, as Vanessa knows, we get every type of crime you can imagine. So every chapter of the book gets consulted and used frequently. So that's helpful. And I guess just background wise, I'm glad to hear that Frank is a visiting scholar at my alma mater, Georgetown. I went there for undergrad and law school, and then, worked at a big firm and clerked for a district court judge down here. While clerking, I wasn't that involved in sentencing. In retrospect, I wish I'd paid more attention once I started in my office, but I did get to see sentencing also from the district court side. So.
Okay, well, let's delve into it, guys. Let's head into it. So we're going to start out with a little bit of the background of how we kind of got here. For a lot of people who may be listening in, watching in, and a lot of practical practitioners, especially as Aimee just mentioned, when you're in federal court as an AUSA or as an AFPD, you the guidelines are there, you kind of know what they are, you're going through the rigmarole of how to, get the best result for your particular client. But with respect to the history and the background, let's talk a little bit about that. How did we get to where we are today with the federal guidelines being developed, and what went into specifically how, I know, Frank, you mentioned talking about assisting with the current iteration of the white collar guidelines. What went into how the guidelines were crafted, like how the numbers were generated, how the levels were generated? Can we talk a little bit about that? Jim and Frank, you want to take the lead on that?
Well, I told Frank I'd start off a little before 1984 and take us up through 2004 and then turn it over to Frank. Because I wanted to have everyone have an understanding of why we had guidelines to start with. Before the guidelines, Congress would set the maximum penalty for the crime, and it would usually set it pretty high. And you could run them consecutively. So if there were multiple counts, you could accomplish a very high statutory maximum penalty. And then sentencing was done almost exclusively by the judge. In my experience, at least in my district, prosecutors didn't generally say anything about what the appropriate sentence should be. They felt it was their job to get the conviction, and it was the judge's job to sentence. And plea bargaining was done by negotiating over statutory caps. So they might give you a 5-year cap. But generally speaking, the prosecutor didn't have too much to say at sentencing, and the judge could do anything from probation to life, effectively. But in those years, somewhere between 33 and 40% of the defendants just got probation. It was not the case that everyone went to prison. Now it's in excess of 90% of the sentences, I think, are imprisonment. So that's kind of where we were when I first started practice. And then there was parole. So whatever the sentence was, the person actually only served between 1/3 and 2/3 of that sentence. So that's why everyone out in the public still believes when they read in the paper that someone was sentenced to 20 years, that they're actually only going to get out after 5 or whatever they think. But and so the public knew that the sentences as they were announced were not the sentences that were going to be served. There was a bipartisan consensus in the early 80s that this was not a good system. The conservatives were concerned that certain judges were too lenient and were not sentencing harshly enough, and were basically giving away the store. And on the left, there was a concern that some of the judges might have either conscious or implicit bias and might be sentencing with a racially disparate impact. And so there was a concern on and a kind of a consensus on both sides, in the person of Strom Thurmond and Ted Kennedy, who put together the Sentencing Reform Act of 1984. And the idea was to create a commission, an expert body that would examine, data and put out best practices guidelines, and judges would then have to follow them. And make no mistake about it, there wasn't much option for the commission that was created in the Sentencing Reform Act of 1984. There was something in the law called the 25% rule, which meant that the commission had to create guidelines that would funnel every case into a guideline range that was no more than 25% wide. That is, the top of the range couldn't be more than 25% higher than the low end of the range. So this is why they have 43 levels in the chart, because they didn't want to have cliffs. And the initial guidelines commission was an interesting cross-section of people, and they struggled. They struggled, for example, with big issues like, should this be a charge offense system or a real offense system? The difference being that a charge offense system, it just is whatever you're charged with, that's what the guideline looks at. And that shifts a lot of authority to prosecutors and away from Congress and away from judges. And so on the other hand, they were worried that this system could be manipulated. And so they ultimately elected what was mostly a real offense system, where no matter what you're charged with and what you plead guilty to, we're going to sentence you for what you really did. And that really did part was basically decided by the judge at a sentencing proceeding, where there were very few procedural protections. And anytime you're writing guidelines that have to be so strict and channel your discretion to such finite points, you're going to, I think, inevitably be pressured, I think, to use things that can be counted. Items that can be quantified tend to be pretty handy. So they migrated toward, for drugs, count the amount of drugs; for a fraud, count the amount of money. Things like, why did you do it? What is the nature of this offender, and what is his characteristics? And was this Jean Valjean who was stealing to feed his family, or was this someone who was never going to get any of the money and was just put in a place where they had to do this? Or was this the mastermind and the initiator of a fraud where they tried to get the money and did, and bought their own Swiss chalet and Maserati? Because the guidelines, unfortunately and sadly, just don't distinguish between those things. So things that were harder to quantify and describe and to write down just didn't make it into the book. And so we had a very strict, narrow ranges driven by an array of factors with few procedural protections that channel discretion into narrow ranges. Sadly, along the way, there came to be an emphasis on cooperation, where if you cooperated and told what the prosecutor said was the truth, they'd throw the whole book away and anything went. And an incredible penalty for those who went to trial. All of a sudden, the factors were more severe if you hadn't cut some plea deal in advance. And very cramped departure provisions, whereas you could have a guideline system with a feedback loop where the commission's looking at what judges are doing and viewing a departure as a positive thing and an expression of a need for improvement in the guideline. The opposite mindset seems to take hold early on, where departures were viewed as an aberration and an undesirable development, and we needed to be tamped down, and we needed to kind of keep everybody on the same page. So, so that's what we got with the guidelines, and along with that, while they were struggling with those issues, we got severity, because Congress couldn't sit still. They passed the Sentencing Reform Act in '84, but before the commission could even put out their guidelines in '87, Congress came along in '86 and passed a bunch of mandatory minimums for drug offenses. Very serious, high offenses. It was the crack extravaganza. And the commission didn't want to have cliffs. And so they were quite clear that they wanted to peg the penalties to the mandatory minimums in the drug guidelines. And then they needed to kind of basically raise all the other penalties so that they would look roughly proportionate. So there's this myth that the guidelines were based on past sentencing practices, and that is mostly a myth. For starters, when they looked at the past sentencing practices, all sentences of probation were discarded and not counted. They were a zero. It's hard to use zero when you're averaging things. Very inconvenient. So probation was simply, the 33 to 40% of the sentences that were probation were just kicked out of the equation. And instead, there was a placement of severity based on the sentences of imprisonment only, with an upward ratchet to account for the new mandatory minimums in the drug laws that had been passed. So we ended up with this really tight system that was then incredibly severe. And then over the years, the only thing that really seemed to be able to happen with them were tinkering in an upward direction. There was just very few instances where amendments were made that lowered the penalties. They were almost always sort of the crime du jour, and Congress would get in the act and say, hey, raise this or raise that, or add a +2 for that, or a +3 for that, or whatever. And the way the scale is set up arithmetically, every +2 adjustment has an arithmetic build-in. So if you add 3 of those, you've just tripled the sentence. And you really haven't looked at, if you just step back and look at what these extra factors were, sometimes they're really somewhat relatively ticky-tack. So we were litigating everything, we were locking up everyone, and it was quite unpleasant. And the Supreme Court came along in a case called Blakely in 2004 involving the Washington state guidelines and held them unconstitutional as a grounds of the Sixth Amendment, your right to a trial by jury. Because what was happening is you'd get a jury trial on the elements of your offense. So say you're charged with mail fraud. The jury gets to decide whether you ever decided in your mind to have a scheme or artifice to take something from someone, and then you either made a phone call or sent an email. So that's what the jury is going to decide. And then the judge, after you've either admitted you did those 2 things or the jury decided those 2 things, is going to deploy this just panoply of factual findings. It's what's actually going to determine whether you get probation or life. And it just looked like the jury's deciding whether you're breathing oxygen, and then the judge is going to decide whether you committed a crime while you were breathing. I mean, everything was being sucked out of the jury trial experience and right. So the Supreme Court struck down the Washington state guidelines with a ruling that, look, any fact that raises the maximum sentence that you're subjected to has to go to the jury, and it has to be proved beyond a reasonable doubt. And so that looked like it would sure be the case with the federal sentencing guidelines. They didn't say that, but it felt like the writing was on the wall. Something's going to happen here. We're not going to be able to keep doing things as usual. Something's got to change. What should we do? And that's where Mr. Bowman can pick it up, because I believe he personally answered that question for us, at least initially.
Well, Jim's absolutely, Jim and I probably still disagree a little bit about some of the old guideline questions. But mostly I agree with his account of how we got up to 2004. I will pause to qualify things a little bit. Insofar as I've always thought that the primary error, and Jim pointed it out, in the original construction of the guidelines was the severity of drug sentences. Because frankly, I think the guidelines would have worked relatively well, not perfectly, but relatively well, had the sentences kicked out by the guidelines, suggested, essentially mandated by the guidelines, not been so universally high. And that became true in the drug case, the case of drugs, because, as Jim said, the commission decided to peg the guidelines levels to the mandatory minimum quantity-based statutory levels created by Congress in '86. And the problem, to really oversimplify a complicated situation, was that once the drug guidelines were so high, first of all, it caused a considerable amount of revulsion among lots of people, judges, and certainly the defense bar, people on the outside, who essentially judged the entire system by these incredibly high and inflexible quantity-based drug guidelines. And then a perverse thing happened. Relative to the drug guidelines, the sentences for lots of other offenses were relatively modest. That was certainly true at the outset for white collar offenses, a point to which I'll return in a moment. But one of the things that people did was, rather than persist in the obvious observation that the drug sentences are just way too high, let's do something about that. Everybody began to compare all the other kinds of sentences to the inflexibly high drug sentences. And instead, what happens is everything else tends to get ratcheted up over the years, in part by comparison to the drug sentences, because you're constantly having arguments like, well, geez, some poor person in the inner city, possibly a minority, is going to do 5 years for 5 grams of crack, but Joe Dokes, the bank vice president, just stole $1 million and he's going to do 2. So we need to equate these in some way. And that and lots of other factors generally tended to get sentences going up and up and up and up and up for a variety of types of crimes, so that within a decade and a half, lots of kinds of sentences other than those for drug crimes became really, really severe. And that continued to make people feel something fundamentally amiss here. We've got this extraordinarily prescriptive, highly detailed, fact-driven system that's producing very, very high sentences and constraining judicial discretion, and there's something fundamentally wrong. I've always thought that what happened in Blakely and the Booker case, which followed it, was in large measure a judicial reaction to the federal judiciary's revulsion against long drug sentences and increasingly long other sentences. It's too long a conversation to get into today, but I think the whole Sixth Amendment superstructure that was first started in Blakely and elucidated on in Booker is constitutional nonsense. It's a complete distortion of the Sixth Amendment. And part of the reason I can assure you it's a complete distortion of the Sixth Amendment is, what are we now, 15 years on? And juries don't have anything more to do with the actual sentencing outcome than they did back in 2004, 2005. It was never about juries. It was always about the constraints that the guidelines put, often improperly, often unfortunately, on judicial discretion. But be that as it may, as Jim says, the Supreme Court, first in Blakely and later in Booker, concluded that they could use the Sixth Amendment to rid themselves of this system that they despised so much. And so what they did in Booker was an interesting two-step. On the one hand, they concluded, relying on the rule in Blakely, that the federal guidelines were themselves a violation of the Sixth Amendment by virtue of the fact that they increased the top of guideline ranges based on judicial fact-finding. And they decided, therefore, that the system was unconstitutional. And you might think that the result of that would be, okay, we just have to throw the whole damn thing out and start all over again and build a new system based on this new constitutional rationale. But they didn't. In the very same set of opinions, one opinion that says the federal system is unconstitutional, and the next concurring opinion says, well, it's unconstitutional, but we can fix it by simply removing, was it one section, subsection, two subsections, Jim, of the Defense Sentencing Reform Act, by essentially making the whole thing advisory. And there is after Booker, a succession of cases went up to the Supreme Court where various aspects of this new and strange system were examined by the court. And time after time after time, for a period of like 5 or 6 years, the courts kept saying, no, we really mean it. They're advisory, just advisory. They can't have any presumptive effect in theory, although it turns out they do. They can't have any effect at all. The ruling in Booker essentially was, okay, from now on, people, here's what's going to happen. You've got to do exactly all the same factual determinations that you had to do before, applying exactly the same guideline rules that were in place before. You've got to do the calculations right, and you've got to produce a guidelines generated sentencing range after you've done all those things. Find the facts, apply the law. And then you can do anything you want, because the guidelines in theory are completely advisory and they're not supposed to count any more than anything else. Now, as I suspect Mike is going to emphasize, it's not quite that way, because in my view, the reason is that judges are, they're lawyers, and they are by nature law and rule followers. They want to make decisions that are roughly consistent with what other judges do, and they want to make decisions in conformity with what they think or see to be law. And as they look around their courtrooms, they look around the legal universe as they're trying to decide this ultimately ineffable question of how much time does Joe Dokes deserve for this awful thing he did. The only thing that looks like law out there is the guidelines, other than mandatory minimum sentences, which they can't avoid. And in consequence, and Mike may elaborate on this more, in consequence, judges have tended to, although they have increasingly sentenced outside of the guideline range since Booker was decided, actually for a year or two afterwards, they sentenced more inside the guideline range, which is an oddity.
Yeah.
But after that, the number of sentences, the percentage of sentences sentenced inside the properly calculated guideline range has declined steadily year by year by 1% or 2% every year, and it's now below 50%. But the sentences nonetheless tend to cluster around the guideline range that's been calculated by the judge. And so the result is a system which, in a remarkable number of ways, looks exactly like the old system. Because if you go to a sentencing hearing, it sounds the same. You're still arguing about the guidelines. You're still making factual presentations about the guidelines. It sounds the same up to the point at which the guideline range is calculated. And we now have a discussion about whether or not the judge should apply a sentence in that range or somewhere else. And there, of course, then we have a reversion to the kinds of sentencing proceedings that Jim was familiar with when he first started, and which I was familiar with before the guidelines came along, and when I was a state prosecutor, in which lots of other factors are added into the mix. But it is a very, very weird system we have, a system that was designed to be highly fact insensitive, extremely prescriptive, extremely limiting of judicial discretion. We have this massive body of law accumulated over all these years that we still apply, but the judges can completely ignore it if they want. It's a very, very odd business. And Jim and I may talk about this more later. The question that I think has been sitting on the table now, really since Booker was decided, and certainly once the Supreme Court said, yeah, we really mean it, these guidelines really are supposed to be advisory. The question that's sitting on the table is, why on earth don't we change this? Endless man and woman hours are spent calculating, finding facts and calculating guideline ranges, which in theory are next to legally meaningless. And the question is, why do we do it? Jim and I may come back and talk about why we continue to do it. But why don't I just stop there?
Jim and Frank, Frank, that was a great background, Jim. But thank you both for doing that. I do have one question before we switch to Aimee. And Aimee, I'll talk a little bit about, practically speaking, how does this play out? I mean, Frank, you talked about the guidelines being advisory, and any of us who've practiced in the federal sphere know that. But from a realistic perspective, they don't seem that advisory. And Aimee can shed a little bit more light on that. But before we turn to her, I want to ask you guys both, in terms of the history. Now, Jim mentioned that, the starting point was analyzing data to go into what levels would be calculated, what ranges would be calculated, of course, along with the mandatory minimum set by Congress and the maximum. But how, and I'll give you an example, to go off this point, but how was the data that was being used made to change for future instances? And my examples with respect to, for example, like the child exploitation sphere. If you look at the guidelines for child exploitation offenses, one of the enhancements deals with use of a computer. We can all agree that every child pornography offender out there who's in the federal system has used a computer, because no one's really trading CDs in the mail anymore. The guidelines don't seem to have any sort of build-in, if you will, for changing with times. So I don't know if you both can address that, like with respect to how they're updated, changing over time, moving out antiquated language that doesn't deal with things, for example, like electronics and computers, and how technology has changed. What was the thought process that went into that aspect of it?
Well, I'll take a stab at an answer, I guess. And you're right that sadly, guideline language that gets drafted in one year may not look as helpful later. And certainly I think in 1984 or in 1987, when the guidelines came out, not every offense involved the use of a computer. Computers just weren't as prevalent in those years. Now it's probably, just a remote, tiny fraction of these offenses that do not involve a computer, if any. But you can imagine, so in theory, the way to fix that would be that the Sentencing Commission would come along and say, wait a minute, this is not a meaningful factor anymore, let's get rid of it. They have trouble politically doing that, because the takeaway is, what are they going to do instead? Just raise just automatically raise everything by 2? That's what, otherwise the headline is, we just lowered the penalty for child porn. And they're not interested in that headline. And Congress isn't interested in letting that headline fly through. So sadly, you can raise penalties all day long. It is very difficult to lower them, but I've said this, and I'll continue to say it. I believe 2010, when they lowered the penalties for crack cocaine, that was the first time in the history of our republic in which the Congress has ever lowered the penalty for a crime. They've taken conduct that was illegal and made it legal. They've never lowered a penalty before. They're doing that now. They've done it before. They've done it again with 924C in a sense. So we are in a new time, but unfortunately, we don't have a commission. When the commission comes in, they are constrained by politics, and it's very difficult for them to lower penalties.
Let me follow up on what Jim said. This is a bit of a bugaboo of mine. It is very common, and has been for quite a while, to talk about data in the as somehow they're connected as it connects to the guidelines and how data is used and so forth and so on. But nobody or very few people actually tell you what they mean when they're talking about data, because you have to drill down on that. First of all, much, if not all, of the data that has been used over time by the commission to set or adjust sentencing levels is data of a very peculiar kind. The original data set that the commission used was a data set of sentences that had been imposed by judges on allegedly similar or standardized kinds of crimes over some previous period of time. And that's fine, and people criticize that claim by saying, well, they didn't really use the data, or they used it wrongly, or so forth and so on. And there's some truth to all of that. But pause just a moment to reflect on the basic premise. The basic premise of that was, okay, we're going to set up a system that is essentially based on an extrapolation or a reification of historical averages of sentences imposed by judges. Why? Maybe if you are really particularly convinced of the general wisdom of judges in imposing sentences, maybe that makes sense. But if I were going to be setting up from scratch and I had infinite resources and lots of time, I'd be much more interested in the kinds of data that say, okay, what's the connection between a sentence of this kind imposed on this kind of crime for this kind of defendant and an outcome? Whether or not the person is going to recidivate, for example. That kind of data was at least at the outset, not present at all. And in fact, a lot of the data, to the extent that we now have arguments in federal sentencing that are data-driven, as I think Michael's system, this really great service that he's created does, it's really about history. It's about choices that previous judges have made. But that's not, if you think about it, self-evidently the best kind of data. It's saying that judges have some kind of mysterious wisdom about how to sentence people. And I say, why? They've done it, but why are they any better to make those kinds of choices than anybody else? Which of course goes back to the original basis upon one of the reasons guidelines were created in the first instance, which is Congress and other political actors and policy actors were essentially getting into the picture and saying, wait a minute, we think we have at least something to say about what sentences should be imposed, and that judges shouldn't have a monopoly on it. The last thing I'll say about this data thing and let other people keep going here is, I think it is also misleading to suggest that one could ever create a system that was entirely data-driven. First of all, I don't know what data you'd use, and I don't know how you'd use it. I don't know what data would be selected. But the truth of the matter is, while data of various kinds can be useful, in the end, a lot of our sentencing choices have to do with policy and morals, policy and ethics. And a lot of our choices about what punishment someone ought to receive for a certain kind of behavior attended by certain circumstances is essentially a moral judgment. And that's inescapable. So when we talk about data, I'm all for getting more data to inform sentencing choices. But the suggestion that there's some kind of data-driven solution to making an absolutely perfect or even close to perfect sentencing system is ultimately delusional.
Well, before we get to Mike, who I know is very much eager to talk about data and how we can possibly revamp the guidelines with better data at hand, let's talk a little bit with Aimee about practically what happens in federal court. Those of us that have practiced in federal court know that the guidelines play a significant role at sentencing. Aimee, why don't you just talk from a practical perspective about, what you've seen that works with the guidelines in the sense that, the judges cannot be all over the place, but what doesn't work, and, some examples of when, the guidelines may just be antiquated and so forth. Why don't you just let us know your thoughts?
Sure. I think one of the things I want to step back to and highlight is that when we get to sentencing, well, there's a couple of things I'd like to highlight. One is when we get to that sentencing hearing, that's the end of a very long process. And some might argue that process starts, when a person is young and whether they get arrested more often or not, and how their criminal history builds, because that's part of the guidelines. But just focusing on the actual case at hand, there is above the guidelines, let's say, there's a statute, 3553A. And that statute is the overarching statute that tells judges what they can consider. So it's not totally unfettered in the fact that they have to consider, pursuant to that statute, they have to consider the guidelines. And the Supreme Court has said they have to keep the guidelines in their head the whole time they're doing the sentencing. So it is important, but the 3553A also tells us that the sentence has to be sufficient but not greater than necessary. And that we refer to as the parsimony principle. And that means that you want the sentence that is the least possible sentence for what you're trying to achieve. Now, I think as Frank alluded to, and Jim, what you're trying to achieve, I don't know, is always clear, right? Are we trying to achieve retribution? Are we trying to achieve deterrence? Are we trying to achieve rehabilitation? And those are all questions that are constantly being debated. But the statute tells, Congress has told the judges that what they have to consider is not just the guidelines, but also the person's history and characteristics, right? So as a defense attorney, that's something that we hook onto. You say, okay, you've got this guideline, but 3553A tells you you've got to look at the defendant's history and characteristics beyond what's here in the criminal history category or in the offense level it's been calculated. Also, speaking practically as a defense attorney, we start working with the guidelines from the moment we get the case. It's the first thing you do. And it's in some ways, the most important thing is that we know how to use the book, because I understand, like in the state court system in Florida, a lot of times the person will plead to a number. You and the prosecutor will get together and you'll say, okay, this person's going to take 12 months. That's not what happens here. Here we agree to a count. And when we agree to a count, we're calculating a guideline range. A lot of that negotiation is going to be talking to the prosecutor about what enhancements apply, what ones we can agree don't apply. Because there's this, the whole world of relevant conduct, which Jim and Frank alluded to, which is conduct that's not necessarily charged, but that you can be sentenced for. So in our negotiations, we have to keep all of those things in mind, because that relevant conduct, which may not appear anywhere in your indictment, is going to affect your sentence. So that's part of our negotiation, but it's also part of what we're talking to our client about, because Jim and Frank also talked about the trial penalty. You see that trial penalty in hard numbers in the guidelines. So it's not just if someone goes to trial, they're going to get a higher sentence. It's you get 2 or 3 points off for pleading guilty. And one of the conversations I'm always going to have with my clients is the difference in that guideline range and what that means to someone. Unfortunately, sometimes at the higher end, those 3 points actually don't mean very much. If you're talking about the difference between 30 years and 27 years, sometimes that can feel, especially to someone who's very young, that can feel like not a lot of time. If you're talking to a 20-year-old about being in jail for 30 years or 27 years, feels pretty similar a lot of times. So that's worth thinking about when we think about the guidelines. There's also the last, just for people, I don't know if everyone on here is familiar, but really the way the guidelines get to the court, the calculation is through a probation officer. So once someone is adjudicated guilty, whether it's after trial or after plea, probation goes and interviews them and also takes the guidelines manual, speaks to the prosecutor, speaks to the defense attorney. In practice, I think it does come up sometimes where the probation officers are supposed to be making an independent calculation. They do at times seem to take direction from the prosecution as far as what enhancements apply, which can be problematic, but probably a conversation for a different day. But they speak to both sides. They speak to the defendant with the attorney present, and they calculate the guidelines. They basically go through the book and they add up all the different enhancements. They calculate criminal history and they prepare a report that goes to the judge. That report we then have a chance to object to. So there are advocacy opportunities at every point in that, which is that I am often speaking to the probation officer and trying to advocate for my client, about which enhancements don't apply before that report is prepared. Because if I can get them not in the report, I've won. If they're in the report and I'm arguing at sentencing, I may not win. In fact, I'm likely not going to win. So both with the prosecutor and with the probation officer, I am attempting to in other words, to work on the guidelines as presented to the court, so that they are as low as possible, as is appropriate under the law, but as low as I can, as my job as an advocate for my client. And then if I fail in that part and they get in the PSI, as Jim mentioned, there's a body of law interpreting them. And if I think that they're wrongly in there, I file written objections and then we argue it out. And, again, having the prosecutor on your side at that point is very helpful, because the prosecutor is the one who's charged with proving it up. So if I object to an enhancement and we've agreed it doesn't apply, often the prosecutor is in the position of saying, nope, I agree with her and it doesn't apply. And then the judge doesn't have the evidence really to apply it, although I think sometimes they maybe call their own witnesses. Because it hasn't happened to me, but it could, I think. So that's in practicality how it works. And it feels, variances, I don't know if it was Frank or Jim, but I think it's about, judges vary from the guidelines, I think about half the time now, although a good portion of those are for cooperation and substantial assistance. So, variances happen, but it is a battle. I think that's the best way to put it.
Thanks, Aimee. Mike, you want to talk a little bit about, and we all know that during your introduction, you talked about being a full day. Now that you have spearheaded empirical justice, and you can tell everybody a little bit more about that. Tell us your perspective on using historical data and current data from prior sentences, and why do you think that's important in coming up with an organization, if you will, that helps guide practitioners on what they should be advocating for at sentencing?
Sure. I mean, basically, it started with using it for individual clients. And I had done a statistical study in the Journal of Criminology way back when, like 2006, on sentencing disparities between whites and blacks and white collar crime. People forget that the definition of white collar crime includes like embezzlement and many other things besides antitrust crimes. And so there actually is a fair number of people from different ethnic groups to compare. So I've just been interested in a while. I wanted to look at this and use it as a tool to basically come up with a body of law. To a large extent, I mean, that's the kind of thing Frank was talking about. Judges want to touch and feel something that looks like law. And the problem is that the guidelines kind of aren't law, and they're bad law for your client. And so I wanted to dig into actual sentencing data. And it took me a while to get people who were willing to do what I did, but when I figured it out, it seemed to work. I mean, I want to return a little bit to some of these hard numbers. Basically, like, okay, so the guidelines aren't mandatory, judges still give them weight. How much weight? Well, I mean, if we took a look at the 2019 source book, right, the federal sentencing source book, and I think I'm sharing it now, and I think people can see it. I'm going to use 2019 because of COVID. The numbers, the total sentences in 2020 were down to like 65,000, which is relatively low, all things considered, in the last 20 years. So there were 76,000 sentences in 2019 fiscal year. 51% were within the range, the guidelines range. 26% were below the guidelines, but on government motion. So they might as well be in the range. That's a 5K1 cooperator or safety valve or kinds of things that Aimee was alluding to. And then, basically another 2% are above the guidelines. And it's pretty safe to assume the defendants didn't want it above the guidelines. So basically, there's only 21% below the range without a government motion, which is quite significant. That's a lot of people, and in a mandatory system that wasn't happening at all. But clearly judges are listening, right? Why? Okay. Well, I agree with what Frank said. It feels like law. It looks like law. There's a habit. Judges want to follow rules. They want safety in law, and they want safety in numbers in the sense that they're going along with their colleagues. But I think they also want safety in numbers for another reason. I think that what they want is an anchoring effect. They are subject to an anchoring effect. So let me see if I can advance this here. An anchoring effect. It's a term from social science. It's the influence of a suggested number when you're answering a question or making a decision. In other words, things are influential in part just because they're numbers. All right, this sounds a little zany, but the guidelines, remember, are numbers as a whole, right? And what you do is you get your criminal history and your offense level, and you put a human being on a grid. The big old fat guidelines are an instruction manual for this sentencing table. And Frank's very good treatise is also a sort of additional instruction manual for putting a human being on this grid. And then you get a number, which the judge can ignore, but often doesn't. Okay, what's the point of that? Oh, here's the thing. Anchoring effects, even when the numbers are random, judges follow them. So this is extremely well documented in social science in the last 30, 40 years. I mean, Amos Tversky and then Danny Kahneman actually got the Nobel Prize for some of the work that included this, right? Behavioral economics, actually, it's the psychologists who came up with it. Classic study, German judges, average of 15 years in the bench. They're given a fact description of a woman shoplifting. And then they're given a pair of loaded dice. And the dice can only come up with a 3 or a 9. And on average, the people who rolled the 9 gave a sentence of 8 months. And the judges who rolled a 3 gave a sentence of 5 months, right? The number they rolled seems to influence them. This sounds crazy, but it's repeated again and again and again, and in many domains that have nothing to do with judging. So you go to real estate agents, you give them a description of a house that's actually on the market in the place where they're working, and you say, how much should this sell for? And you tell them a different price that the client wants to put it on the board for. If you tell them a higher price, they give you a higher value. And then one of the first ones done by Kahneman and Tversky is literally spinning a wheel of fortune, a roulette wheel, again, weighted 35 or 65, and then asking the question, how many countries in the United Nations are in Africa? How many African countries are there in the United Nations? People who rolled the lower numbers, guessed lower numbers of countries in the UN and Africa than people who did the higher ones. We follow numbers. And then when you add to this the fact that the court commands people, the Supreme Court says you got to consider them, and they look like law, and they're used to doing them. It's not surprising that they influence and they pull up. It doesn't mean that judges are automatons and they don't think about it and do it. I've never met a judge who wasn't serious about sentencing, thank God. It just hasn't happened yet on either side. I've disagreed with them, but they all really had reasons. You know, the numbers matter. And yet, we could change it. Imagine if you had the sentencing table and beneath these numbers, you actually had the median sentence in the particular position on the table, or 25th percentile, median, 50, 75. All of a sudden, you'd have numbers competing with numbers. You can do it with a graph. So this is from the Sentencing Commission's data. They make it all available in a really annoying format, like you got to use SAS or SPSS, but you use it. This is just 5 years of data for the primary fraud guideline, 2B 1.1, with a criminal history of 1, an offense level of 17, which is a range of 24 to 30 months. That's the grade part. Now, this is lower on the guidelines table. That's not an accident. And crucially, it's in criminal history category 1. That's not an accident. If you go into larger criminal histories, you're likely to get judges sticking to the guidelines more. If you go deeper in the table, also a little bit more stick, but less than you think. What's going on here? 68% of cases at this particular position are beneath the range. And precisely as Frank was alluding to, or perhaps it was Jim, I think we're all sort of got a grip on this stuff. People cluster, the judges cluster around the range In fact, they stick the landing at the precise bottom. What do I think is going on? These judges here, the judges over here at probation know they're being lenient. The judges here at 24 months think they're being lenient. If they knew that 68% of cases for that particular position on the guidelines, with that particular Chapter 2 guideline, were going beneath it, I think they'd be interested in moving because of safety in numbers, because they want to follow law. Is this a substitute for being an advocate and telling stories? Of course not. If you have a 30-page brief, this is the kind of thing that should take up 3 pages, okay? Like, I agree with my old professor, Judge Gertner, former Judge Gertner, who, fantastic advocate, fantastic judge. Tell stories, okay? Do not be obsessed with data, but understand it and use it. And I think this is extremely powerful for judges and shows them. I mean, by the way, this sample includes over 1,000 people. This is not cherry picking 2 sentences or something absurd. And then you might say, okay, fine, but what if those are all cooperators? Well, I won't show you another graph, but basically this number of 68% becomes 59%, still below the guidelines if you strip out cooperators. The median here on this graph, the median sentence, 50% of people are getting 12 months or less when the guidelines are 24. Okay, you take out cooperators, 42% are getting 12 months or less. Still real. Now let's look at a particular district. Last 5 years in the Southern District of New York, a lot of fraud cases in Southern District of New York, 136 people. I deliberately stripped out the cooperators. You can show this data to people at the national level, the circuit level, the district level. It's just the distribution of sentences. There are no regressions. There's nothing going on here that's extremely mystical or complicated. It's pretty straightforward. It's one particular tool, but I think it's extremely valuable. Okay, last, just because I wanted to include some drug data. And here I had this little amendment because this is really only the last 5 years. So not including 5K1, across the country, 1,700, more than 1,700 individual defendants sentenced. And you'll still see huge clustering at the bottom of the range, 39%. What if those people knew that still most cases were lower? Okay, what is the point of all this? I think the point is to try to get a common law of sentencing. Now, Frank points out, well, where the hell did these numbers come from anyway? Well, this is true. Basically, Congress punted and wrote a statute that is almost like an outline for Plato's Republic, or maybe a history of philosophy. So they said to the commission, take account of retributive justice. These are the factors in 18 U.S.C. 3553A. Retributive justice. Well, that's like Kantian deontological reasoning. Oh, just desserts. Or maybe you're a poet and you like Dante's Inferno. Oh, let's think about retributive justice and incapacitation. Well, that's Cesar Beccaria and Jeremy Bentham. This is really hard and inherently political, and it was an insane task the commission was given. So what did they do? Very cleverly, they also punted and said, we're going to derive the rules from existing practice for what judges have done. And they took these studies, and the studies have a lot of flaws. Jim mentioned some of them. There are many more. I mean, there are enormous flaws with the ways that those studies were done. But it was an attempt to try to find some kind of existing body of law from which we could then do things. My point is, we're stuck with this damn thing, for better or worse. And this, at least, is a way to be dynamic about it and have the feedback we've talked about done by individual judges so that decisions start creating this body of law. We're a country with a written constitution. This feels inelegant and ridiculous, and maybe it is, but it's what we got. And we can try to work on it. And frankly, without the commission having a lot of people on it, this is what I think is more likely to stick. Basically, I'm hoping this is a common law of sentencing. Somehow we got the restatement of sentencing without ever having had a common law. By the way, Frank said to an associate, go get me the restatement. And what I'm usually referring to is your treatise. Like, this is the kind of thing, because what do you get? What kind of law do you really get? Judges don't write opinions on sentences. They go, let's do an interpretation of this particular provision of the guideline. But that's not a list of reasons why they sentenced a person to a particular thing. The best we've got, to a large extent, are these stats, except the commission deliberately decides to de-identify the data they collect. They don't let you get individual cases. They don't put judge names, case numbers. There's about 1.4 million sentences since 2006. I've re-identified about 550,000. I would not run stats in that because I'm not sure exactly what's not getting picked up. But it's a body of case law of identified cases you can then cite to a judge. So just to round this out, and the last thing I'll say here, basically, it's a 1-2 punch. You take the stats, and then the prosecutor might say, well, that distribution is great, but your guy is in the 10% worst. So he's hanging out at that bad tail. Then you want to have individual cases to compare it to. And someone like Aimee, who knows her district, there is nobody who knows sentencing better in a particular district than the federal defenders. I turn to them all the time in private practice for intel on judges. They know it. And they have enough of a knowledge of the cases in their district that they can often find an example. Or there's a list we've been passing around for years on the FCPA cases. I'm sure Jim has a copy. All of that stuff, right? Oh, here are the last 5 politicians to get sentenced. But in general, you can't think of those examples. That's what the database of sentences is supposed to help people do. So you take your stats and you say, here's the baseline, judge. And then the prosecutor goes, wait a second, he's one of the 10% worst. And you go, no. He's like these 2 other people who got sentenced to half the guidelines range. It's a 1-2 punch of the stats and the anecdotes. And it really should only be a small portion of what you do. But quite frankly, I don't see why you would ever avoid that. Putting aside theoretical reasons for reform, I think this is, practically speaking, the best way to get similar defendants treated similarly at a lower number than they're getting it now.
Thanks, Mike. I think we can all agree the data that you've compiled in empirical justice is pretty amazing. It's neat to see, and I think it's very useful. I do want to shift and talk a little bit about what you said, and we'll end on this. You said that we're stuck with what we got, the system that we got. And many people feel that way, that any sort of changes really to the guidelines, any changes, with the commission doing anything, what little commission we actually have is theoretical at best. It's not going to actually occur. But I do want each of you to talk a little bit about what the problems are, the major problems you see with the current state of affairs, the current set of guidelines. What are the major, issues before us? And if we could revamp it, if we could change it, how would you do so and why? Aimee, why don't we go ahead and start with you?
Sure. Thanks, Vanessa. I think there's always going to be this tension that we've talked about between uniformity and proportionality. And the guidelines themselves talk about how they wrestled with them. To anyone watching who hasn't actually read the first chapter of the guidelines, it's a pretty good place where they talk about how they were formed and how they got there. And I honestly think that in a lot of ways, I think judges are doing the best they can with what they have. And there's this tension exists, and it's something that we have to wrestle with. I think one of the problems that was highlighted by Jim earlier was that when the guidelines were formed, we threw out these probation sentences, and we ended up with these higher numbers, and we're starting from a place that's higher. So if we were going to do a revamping, I think we'd want to look back at the data, and there is also a statute that tells the commission that first-time nonviolent offenders should be eligible for non-serious offenses, should be eligible for non-jail sentences. And it just doesn't happen. That statute has really not happened. And I think that, there is a way to amend and work with what we've got to make it more reflective of what our society wants. Another thing I think about a lot is all the research that I've read is that length of sentence actually doesn't have the deterrent effect as much as certainty of being caught. So it's a question of, if we decide to shorten prison sentences and we save money that way, should we put that money towards assuring people get caught? because and that will make us safer. You know, really in the end, the real reason why we're doing all of this is because we want to be a safer place. And I think that there are ways to do it that are smarter than what we're doing right now. I do think there's political risk in it, which makes it hard. But there and I think, I mean, to start with, we could, you know, have a sentencing commission with all the commissioners on it and maybe add a defender ex officio. You know, I know that there is a DOJ ex officio. It'd be nice if there was someone for the defense committee also always there too. So those are some thoughts that I've had.
Oh, I just want to briefly second the idea of the ex officio. I've always thought that, frankly, it'd be an amazing benefit if there were a single federal defender in the way that there is a U.S. Attorney General, that would focus debate. I mean, the DOJ is the most successful lobbyist in Washington. And briefly, because I really don't have too many ideas on how to make the guidelines better that I think are concrete. One is, tying on to what's been said before, I'd like less countable stuff. And when we count things, I want them tied to changing circumstances. So for example, the loss guidelines should be indexed to inflation. From 1987 to 2016, there was no adjustment for inflation, which is crazy because stealing $100,000 in 1987 was a much bigger deal than stealing $100,000 in 2016. So less countable stuff, indexing to inflation, the countable loss. There are other potential things we could do. I guess the last example, I remember as a prosecutor, I had a child porn case with a guy who was an obsessive pack rat as well. And so he backed up all of his vile images and had them in the closet. There was no sign he ever looked at them or distributed them. Doubling his prison sentence because he backed up his images was insane. We didn't. The guidelines were advisory, so they didn't have to happen. But it was actually a struggle to get there. That kind of a thing should be accounted for.
Yeah, I agree, Mike. And I think we can all agree here that, you know, the fact that the guidelines haven't really changed since the late 80s and accounted for computers, electronics, inflation, all those sorts of things that really are just baseline, is that's a good starting point. Now, we're going to end with Jim and Frank and both of your thoughts on the guidelines and, you know, how in a theoretical world with a functioning sentence commission we could possibly change this. But I do want both of you also to touch on one point. We speak a lot about using historical numbers, and we speak a lot about using historical data and, you know, really taking averages. Even if you do that, that really takes into account a system that has not boded well for certain parts of society and certain demographics. And if we're going to make the criminal justice system, you know, fair, if you will, and take into account race considerations and so forth, how do you do that? How do you make a system that's fair when the system for so long has been unfair to certain demographics, and that's been built into the system? I'd like to hear your thoughts on that as well as we end.
Well, I'll take a quick stab at the present and the future, and I'll try to speak first about things that are practical and real, and then I'll end with some theory. Where there is going to be a new sentencing commission, this administration is taking its time, but it's going to nominate a commission, and it'll be confirmed, and it'll be bipartisan, and we will have a new commission, and you know, if not by the end of this year, shortly into next year, I would guess. What will be front and center for the new commission will be what has come to be known as a second look or compassionate release. Right now, we are reaping the fruits of all this over imprisonment and over incarceration we've been doing since the guidelines have come in and before. And because there's no commission, I won't explain the details of why this is so. Courts, except in the 11th Circuit right now at the moment, have the authority to revisit these sentences. And so the new commission is going to be asked to look at that. And there's going to be quite a debate in this country, I think, about second look and whether or not it's appropriate for judges to have some greater authority to revisit long sentences long after the fact. The new administration is going to take a look at their charging and plea bargaining policy. They immediately reinstated the Holder memo on charging and plea bargaining, but this president ran on a platform of no mandatory minimums. So those of us in the advocacy community are going to be lobbying and advising that they should have a new policy that says thou shalt not charge a mandatory minimum. But in any event, there is a new group at the DOJ, and they're putting together a new charging and plea bargaining policies, and that'll be interesting to watch. I think it's possible we could get legislation that makes the changes to 924C and its stacking provisions that were eliminated in the First Step Act, but not made retroactive. Those need to be made retroactive. I think it's possible that we could get legislation lowering the 18-to-1 crack penalty down to crack powder disparity down to 1-to-1. We've got an issue where we let a bunch of people out of prison for COVID and the BOP wants to put them back in. So that's a pretty hot topic in terms of, are we going to be able to do something about that? We have what is called the Risk and Needs Assessment System in the First Step Act. And this is something that I think not too many folks understand yet, but we're going to be letting people out of prison early. And we're going to be using math. We're going to be using an algorithm. We're going to be using a risk assessment tool called Pattern. And it's going to break or has been used already to rank order federal prisoners by risk of recidivism into 4 categories of risk. So we're going to release people based on what the math says they might do in the future, not what they did in the past. And I'm deeply concerned about this tool. The tool and the math will tell you how to rank order 100 prisoners according to risk 1 to 100. It does not tell you where to draw the 3 lines on the page. They're called cut points to separate the people. And under the First Step Act, only prisoners in the 2 low risk categories get any credits for the programming they participate in. So they put the cut point not in the middle, but at the middle of the low half or the bottom quarter. And they haven't ever said why. They doubled the number of points you get for criminal history in the tool, and they have not admitted they did it or explained why they did it. And I think it will have the effect of causing an incredibly racially disparate impact, but we don't know that because they won't release the numbers. And there's been very little, if any, transparency about what went into the creation of the tool. And we have a proposed earned time credits rule that the last administration proposed that would largely gut the ability to get the credits in the first place. So this administration has before it some very difficult choices to make about whether to change that earned time credits rule, whether to revisit some of these pattern issues. And in theory, if what we would do is we would scrap the system we have now. It is silly to calculate the culpability, slice it 43 different ways, litigate all these points, and then afterwards toss it aside and do what you like. So I think that among many, I will say, there's a consensus, I think, that some guidelines are better than no guidelines. Now, I may be in the minority as a defense attorney there, but I happen to think guidelines are better than no guidelines. The judges deserve and can use and benefit from guidance. But I think there's also a consensus that there's no need to have guidelines that are that detailed that it slices things that finely, and that the boxes could be much wider, and that they could be based on much simplified and broader considerations that have simply got to focus on not only the nature of the offense, but the nature of the offender. Offender characteristics and culpability have got to be considered. And you could readily create a simplified system of guidelines that would be pretty satisfying to a lot of people. And that would be the way that you could perhaps address mass incarceration, because it may be the only way you could get lower ranges across the board. The concern, and I think it's a legitimate concern, and honestly, I may even share it myself, is that as a political matter, if you go through the trouble to rewrite this system and you come up with a new book that's so simple that it can be looked at by a jury, some politician's going to want to make it binding again. Some politician's going to say, I don't really trust judges. I want to make those juries find those facts, and then I want to make judges have to stay within the box that's driven by that. And constitutionally, they could do that. So the hesitancy in the advocacy community over the promise of scrapping this book as the way to get rid of over-incarceration and get lower across the board sentences, the fear is that in the wrong hands, it'll be turned on us. We'll lose what we've got now, which is judges can actually judge. And it does not look like the same sentencing proceeding it used to. The first half looks the same. The second half is completely different, and it's an actual sentencing proceeding. And so the fear is that we might gain, but we might lose. And so I think we're at stalemate there. So I think these more practical, short-term, small gains are what we're in the game for right now.
Well, let me pick up from what Jim said, and let me start with by sort of weaving a couple of things together that have been said. Jim talked about the emphasis now on a second look, which essentially raises the question of where the power to determine how long someone should stay in prison should reside. When the guidelines were first enacted in the federal system, in most states, the power to determine how much time you actually did was shared. It was shared by judges imposing a front-end sentence of up to so much time, with parole commissioners or a parole board, some sort of parole authority, who evaluated the progress, if you will, the evolution, the behavior, whatnot, of an incarcerated defendant after a certain period of time and progressively over time, and decided whether or not the person ought to get out sooner than the maximum that the judge imposed. One of the critical things that the Sentencing Reform Act of 1984 did was to eliminate the back end. There is no parole in the federal system. And perversely, while in a certain sense, of course, the guidelines were intended to deprive judges of discretion and sentencing authority, in a perverse sort of way, the creation of the guideline system actually gave the judges more power than they ever had before. Because now, ever since 1984, 1987, when the guidelines became effective, the only decision effectively that really matters is what the judge decides at the front end. And there, as Jim says, there are some administrative niggles that can be arranged later. But basically, we created a system in which there isn't any system for back-end examination of federal sentences. And that, I think, is one of the principal errors that the Sentencing Reform Act made. Why did they make it? Complicated story, but one of them relates to something that I think maybe Vanessa said, or the notion that, or perhaps it was Aimee, the idea that deterrence seems to be based primarily on certainty of punishment rather than length. And actually, that was one of the ideas behind the original compromise that created the guidelines. The idea was to create a system in which, across the board, some sort of incarcerative punishment was going to be much more likely. But the original designers, up to the point where the drug sentences got thrown out of whack, really had in mind this notion of more certain but relatively short, relatively moderate penalties. Well, if that's the model, if they'd managed to stick with that, then it doesn't really bother you too much that there's not going to be a second look. You can throw out the parole commission if most sentences are fairly short. But instead, what we've created over time, for all the reasons we've talked about over the last hour and more, is a system which is highly prescriptive, highly punitive. It's imposing very long sentences, and we've gotten rid of the back end. And I think that one of the best things that we could do, because I have no confidence at all that a new sentencing commission, a new Congress, a new president, any combination of those is going to be capable of recreating the particular magic particular political magic that allowed for the creation of the Sentencing Reform Act back in 1984. It's just too damn complicated. And we have a Congress that basically can't pass a budget. The notion that they would be able to collaborate in that kind of really complicated process seems to me extraordinarily improbable. And without them, the commission can't do all that much. So I think in the short term, the kinds of incremental improvements that Jim is talking about provide the best hope. And the last thing I would say is maybe Congress might be convinced to formalize some sort of revived parole second look mechanism in my view, it should be independent of the judges. That would perhaps provide both some equalization of disparate sentences and an additional degree of human judgment once people had gotten into their term of incarceration. We could talk about lots more, but that's all I got for right now.
Yeah. Well, I think that we'll have to save the rest for another time because we've run over 5 minutes over our slotted time, and I don't want to keep everybody up for much longer. But I do thank you all for this discussion. It's prime, it's necessary. We need to keep talking about the guidelines. We need to keep talking about sentencing and how to make it work. And Mike, I think that empirical justice is awesome and amazing and a really good start. I appreciate everyone's input. And if anyone on the call that's not part of the panelists has any feedback for us, you guys can send an email to ACS and they'll get that to us. Sorry, we couldn't answer questions and provide for more time in that, but hopefully we can have more panel discussions in the future and cover this timely topic. Thank you, everybody.
Thank you.
Thanks, guys.